the extent our equal protection clause is coextensive with the federal one?
There have been for example, two federal district court cases in recent years cited in our brief, the Smelt case and In re Can-Do, that have themselves said that they don't view Baker versus Nelson as binding even on federal courts. So I don't think this court even has to go that far. And then I'd like to turn as well to
So what do you extract as the binding equal protection jurisprudence of the Supreme Court of the United States on this issue?
Well, as the opinion I just read says, the federal law is still an open question under federal law. I think there are important cases such as the Zablocki case.
So it's just a completely open issue?
There's a lot of guidance from cases in federal law ranging from Griswold versus Connecticut, the Eisenstadt case, which held that the right to privacy and autonomy in making decisions about whether or not to use contraception was not just a right for married couples, but also a right for the unmarried, and required the court not to define a right in narrow group-based terms.
Do you agree with Justice Scalia that in Lawrence v. Texas basically makes it impossible for the Supreme Court not to hold that gay marriage is permissible?
Well, I certainly do believe that Lawrence versus Texas's teaching and the methodology it follows does mean that any fair application of due process and equal protection doctrine should lead to the conclusion that it is unconstitutional to deprive same-sex couples of access to civil marriage. Yes.
So when they said we're not deciding that and Justice Scalia said don't believe it, you think he was right?
Actually, I believe that what Justice Scalia was right about is that Lawrence is a case that makes very clear how other courts need to address the question of marriage rights for same-sex couples. I think that the Lawrence majority certainly didn't reach the question and was careful to make clear that it wasn't. But I also think Lawrence is important for questions that have come up earlier about whether we're asking the court to define a new right to so-called same-sex marriage, or to simply acknowledge that the right to marry, the well-settled fundamental right to marry, can't be defined so narrowly on group-based terms to exclude an historically excluded group. And in Lawrence, the court overruled Bowers versus Hardwick, which the Lawrence court said Bowers's description of the right at stake and in Bowers' court said it was facetious to claim that there was a right to homosexual sodomy. The Lawrence court said that misapprehended the nature of the right at stake. It was a right to individual autonomy in making decisions about one's private sexual relationships and bonds with another, and that it demeaned the dignity of lesbian and gay people. So,
had Baker relied on
Bowers?
Yes.
No, Baker predates Bowers. I'd like to also turn to the discussion about the Turner versus Safley case, because I do believe that Turner is a case that's very on point and important, and I don't think that it's fair to characterize it the way I heard it characterized earlier. I think Turner versus Safley upholding the right of a prison inmate to marry, it's clear that that prison inmate had no ability to engage in procreative activity, and if there's any question about it, I think we just look at the decision of the court below in the Eighth Circuit, which we did cite in our briefs. It's 7-7.